Welcome to Global Online. In today's session, we will solve legal reasoning passage and MCQs from previous CLAT exams. We will focus on how to extract the legal principle, apply it correctly, eliminate wrong option, and select the most logical answer exactly as required in a CLAT exam. A new live CLAT batch is now available for student. A new live CLAT batch is now available for student who want complete and guided preparation. This batch includes live interactive classes, updated legal reasoning techniques, topic-wise notes and worksheets, full-length mock test, regular performance tracking, and doubt-clearing support. So let's begin and sharpen your approach to legal reasoning for your CLAT exam. So first, we will read this passage. The Indian legal system places a significant emphasis on protecting the rights and welfare of children. The Juvenile Justice, Care and Protection of Children Act 2015 is a vital piece of legislation in this regard. It is designed to ensure that children in conflict with the law receive special care, protection, and treatment, with the ultimate goal of their rehabilitation and reintegration into society. One of the key provisions of the Act is the establishment of Juvenile Justice Board, that is JGB, at the district level. These boards consist of metropolitan magistrate or judicial magistrate of a first class and two social workers, at least one of whom should be a woman. The primary function of the JGB is to determine the age of the juvenile, the circumstances in which the offense was committed, and whether the juvenile should be sent to a special home or released on a probation. The Act makes a clear distinction between a child in a conflict with the law and a child in a need of a care and protection. A child in a conflict with the law is one who has committed an offense, while a child in a need of care and protection is a child who is vulnerable or at a risk and requires special care and support. The Act introduces a unique approach to dealing with the children who are in a conflict with the law. For children between the ages of 16 to 18 who have committed heinous offenses, they can be tried as adults subject to a preliminary assessment by the Juvenile Justice Board. This assessment considers the child's mental and physical capacity to commit such an offense. If the board determines that the child should be tried as an adult, the case is transferred to the regular criminal courts. The Act also places restriction on the publication of information that could lead to the identification of a juvenile offender. This is done to protect the privacy and future prospect of the child. We can summarize this passage as the passage explains that the Juvenile Justice Act 2015 focuses on special care, protection, treatment, rehabilitation, and reintegration of children who came into the contact with the law. Rather than on punishment, it introduced Juvenile Justice Board at the district level composed of a metropolitan or justice magistrate of the first class and two social worker, at least one woman, to assess the age and circumstances of a juvenile and decide appropriate rehabilitative measures. The Act clearly distinguishes between child in a conflict with the law and a child in need of care and protection, and it allows 16 to 18-year-old accused of heinous offenses to be tried as an adult after a preliminary assessment by the JGB, while also restricting publication of details that could reveal a juvenile's identity to safeguard their privacy. So we have first question here: what is primary objective of the Juvenile Justice, that is Care and Protection of Children Act 2015? So the question is asking about the main aim of the act as described in the passage, not any side feature or general child right goals. So in the first paragraph, the passage states that the act is designated to ensure special care, protection and treatment for children in a conflict with the law, with the ultimate goal of their rehabilitation and reintegration into the society. So we have options here. Option A, to punish child offender. This is opposite to the passage emphasis. The act is reformative, not punitive, and focuses on care and rehabilitation instead of punishment. In case of option C, to remove all form of violence against children. This is too broad and is not stated as the specific objective of this act in this passage. The focus is on children in a conflict with the law and their rehabilitation, not on all forms of violence in a general. While in case of a D, to increase the age of a criminal responsibility, the passage does not mention any change in the age of a criminal responsibility. Instead, it discusses how 16 to 18-year-olds may be tried as adult in heinous offenses after the assessment. But in case of option B, to rehabilitate and reintegrate children in conflict with the law, this matches the ultimate goal expressly mentioned in the passage, rehabilitation and reintegration into the society. So option B is the correct answer here. We have next question, who makes up the Juvenile Justice Board, that is JJB. So the question asking about the composition of a JJB as given in the passage, exactly which members from the board. So in the second paragraph, the passage states that the JJB consists of Metropolitan Magistrate or Judicial Magistrate of the first class and the two social workers with at least one being a woman. So in case of option A, two judges, the passage mentions only one magistrate plus two social workers, not two judges. So this is a factually incorrect. In case of option B, a metropolitan magistrate and a two lawyer, the passage specifies two social worker instead of two lawyers. So this is not match the given composition. In case of option D, three police officers are not mentioned as a member of a JGB in the passage. The board is a judicial plus social worker based. So this one is a wrong option. While in case of option C, a metropolitan magistrate or a judicial magistrate of a first class and two social workers, this option precisely mirrors the description in the passage, including the magistrate plus two social worker. So option C is the correct here. Next question is, what is the role of a juvenile justice board, that is JJB? So this question is asking what the JJB actually does according to the passage, its key function, not just any general power. So the second paragraph explains that the primary function of the JJB is to determine the age of a juvenile, understand the circumstances in which the offense was committed, and decide whether the juvenile should be sent to the special home or released on a probation. There are all assessment and rehabilitation oriented functions. So in case of option A, to determine the punishment for juvenile offenders, the passage does not say the JJB determines punishment. In a penal sense, it stresses assessment and deciding on rehabilitative measures like special homes or probation, not punitive sentencing. That's why option A will be wrong here. In case of option B, to decide whether a child should be sent to a regular prison, the passage never mentions regular prison as an option before the JGB. Instead, it speaks of social homes and probation, which are child-friendly alternatives. In case of option D, to prosecute child offenders, prosecution is a function of the prosecution or a state, not the JJB as described. The board's role is adjudicatory and rehabilitative, age and circumstances assessment, placement decisions, not to act as a prosecutor. In case of option C, to assess the age and circumstances of the juvenile and make decision on rehabilitation. This one matches with the passage directly. Determine age, examine circumstances, and decide on special home or a probation, which are form of a rehabilitation. So option C is correct here. Next question is, what is the distinction between a child in a conflict with the law and a child need of a care and a protection? This question tests whether you can differentiate between two categories of children as defined in the passage. In the third paragraph, the passage clearly states that a child in a conflict with the law is one who has committed an offense, whereas a child in need of a care and protection is a child who is vulnerable or at a risk and requires special care and support. So in case of option A, there is no distinction, both terms mean the same thing. This directly contradicts the passage which explicitly says the act makes a clear distinction between two categories. In case of option C, a child in need of a care and protection is more likely to commit crimes. The passage does not say anything about likelihood of committing crimes. It describes this child as a vulnerable or at a risk and needing care, not as more likely to offend. In case of option D, a child in a conflict with the law is an adolescent of. This statement is incomplete and even If interpreted, the passage focuses on the fact of having committed an offense, not merely age or adolescence. So this does not match the definition. Option B, a child in a conflict with the law has committed a crime while child in need of care and protection is vulnerable or at a risk. This restates the exact distinction given in the passage, offense committing versus vulnerable, at a risk and needing care. So option B is the correct answer here. So guys, that brings us to the end of today's legal reasoning PYQ session. These questions are essential for building speed, accuracy and exam ready confidence. Students who want strong self-study support can check out the Law CET and CLAT book by Global Online Publication, one resource for complete preparation. This book includes entire syllabus covered in a structured manner, chapter-wise concept explanation, practice question with the solution, previous year paper included, mock test for real exam experience, quick revision notes and exam strategies. So the purchase link is available in the description. Like, share and subscribe to Global Online for more CLAT preparation content. See you in the next lecture. Thank you.